Something changed at work. Maybe you were passed over for a promotion that went to someone 20 years younger. Maybe your performance reviews turned negative after a decade of strong ones. Maybe a new manager arrived and suddenly you don't fit the direction they're taking the team. Now you're wondering, is this age discrimination? Or is it just how things go? Here's what I want you to know. Nearly 1 in 3 age discrimination claims filed with the EEOC are found to have merit. But most employees never file because they don't know what the law actually requires them to prove or what evidence they're already sitting on. I'm going to show you exactly how to identify it, document it, and build a case that holds up. Here's what you're getting in this video. First, I will tell you what the ADEA, the Federal Age Discrimination Law, actually covers, including some things employers assume are legal that aren't. Second, I will show you the specific language and patterns that courts have found to be evidence of age discrimination. Third, I will walk you through the 4 types of evidence you need to build a case. And fourth, you will get your to-do list, the steps to take right now, including one you should take before you sign anything your employer sends you. If you find this useful, then please like and hit subscribe. New video every Tuesday. I'm a lawyer. I've seen age discrimination cases from both sides. Let's get into it. Key insight number 1, the Age Discrimination in Employment Act. The Age Discrimination in Employment Act, or the ADEA, is the primary federal law protecting workers from age discrimination. It applies to employees who are 40 or older at companies with 20 or more employees. Here's what it covers: hiring, firing, promotions, pay, job assignments, training, benefits, and layoffs. Any employment decision that disadvantages you because of your age. Here's what most people don't know. The ADEA also covers harassment. Age-based comments, jokes, or a hostile work environment targeting older employees can give rise to an ADEA harassment claim, not just a discrimination claim. Here's what the ADEA does not cover: companies with fewer than 20 employees, workers under 40. And here's the one that surprises people. The ADEA does not allow you to claim damages for emotional distress the way Title VII does. Your recoverable damages are economic: back pay, front pay, and attorney's fees. That's why economic documentation matters so much. One more thing worth knowing. Many states have their own age discrimination laws that are broader than the ADEA. New York's law covers employers with 4 or more employees. California's law covers employers with 5 or more employees. If you're in a strong state, you may have more protection than the federal floor. Key insight number 2. Common age discrimination phrases. Age discrimination rarely announces itself. Employers are careful not to say, "We're letting you go because you're too old." But the language they do use often tells the same story, and courts have recognized that. Here are the phrases that have appeared in successful age discrimination cases as evidence of discriminatory intent. "We need someone more energetic." "We're looking for fresh perspectives." "We need someone who can grow with the company." "We want to build a younger culture." "We need someone with more runway." "He's set in his ways." These phrases don't explicitly mention age, but in the context of a 54-year-old being passed over or pushed out, they paint a pretty clear picture. The other category of evidence is statistical. If your employer laid off or fired a disproportionate number of employees over 40 while retaining younger employees with similar or weaker performance records, that pattern is evidence. It's called disparate impact, and it's a separate basis for an ADEA claim. There have been cases where the smoking gun was a single email, like the one I covered back in episode 8. The manager wrote "younger energy," and that phrase became the centerpiece of a $2 million settlement. The language people use when they think no one is watching is often the most honest evidence in the case. Coming up next is an on-screen graphic with the list of phrases that have been used as evidence of age discrimination. Key insight number 3, the but-for standard. I want to be honest with you about something that makes age discrimination cases harder than other types of discrimination claims. Under the ADEA, you have to prove that age was the but-for cause of the adverse employment action. That means age has to be the determinative reason, not just one factor among several. If your employer can point to legitimate business reasons for their decision, even partial ones, it becomes harder to win. Under Title VII, which covers race, sex, religion, and national origin discrimination, you only have to show that discrimination was a motivating factor. The standard is lower. This difference matters. It means you need stronger, more specific evidence for an age discrimination case than you might for other discrimination claims. Circumstantial evidence alone, without some direct indicator of age-based thinking, is harder to win on. That doesn't mean you can't win. It just means you need to be systematic about building your evidence, which brings me to the 4 types of evidence that matter most. Key insight number 4, how to build a case. Here are the 4 types of evidence that matter most in age discrimination cases. Type 1, direct evidence. Statements, emails, or communications that explicitly reference age or use code words for age. Things like younger energy, fresh perspective, someone who can grow with us. Save every email. Screenshot every message. Forward relevant communications to a personal account before you lose access. Type 2, comparative evidence. Were younger employees with similar or weaker performance records treated differently? Were they retained when you were let go? Were they promoted when you were passed over? This comparison is often the backbone of an age discrimination case. You need names, roles, performance records, and outcomes. Type 3, timeline evidence. When did the negative treatment begin? Was there a triggering event? A new manager, a birthday, a company reorganization? The timing of sudden negative performance reviews, reassignments, or exclusions tells a story. Document the timeline in writing now while it's fresh. Type 4, statistical evidence. What is the age profile of employees who were laid off, fired, demoted, or passed over? If the pattern shows a concentration of employees over 40, that's potential disparate impact evidence. Your attorney can obtain this through discovery if you file a claim. Some cases have been built almost entirely on timeline evidence, something like a spotless 11-year record that suddenly deteriorated the month after a new 35-year-old manager arrived. The timeline made the pretext argument almost by itself. Coming up next is an on-screen graphic that shows more details about the 4 types of evidence we just went over. Key insight number 5, severance. Before your to-do list, there is one thing I need to tell you that could be the most important piece of information in this entire video. If your employer offers you severance, they will almost certainly attach a release of claims attached to it. That release will include a waiver of your ADEA rights, and if you sign it without understanding what you're giving up, you may permanently lose your right to pursue an age discrimination claim. The law has specific requirements for a valid ADEA waiver. It must be in writing and be understandable. It must refer to ADEA rights specifically. It must not waive future claims. And critically, you must be given at least 21 days to consider it and 7 days to revoke your signature after you sign. If your employer presents a severance agreement and pressures you to sign it immediately, that pressure itself may be a violation of the ADEA waiver requirements. Do not sign anything your employer sends you after a termination without having an employment attorney review it first. A 30-minute consultation could save you the right to a claim worth significantly more than the severance being offered. Here's your to-do list. 5 steps, start today. Step 1, write down the timeline right now. When did things change? What happened right before it started? Who said what and when? Do this today. Memory fades and details matter. Step 2, save every relevant email, review, and communication. Forward to a personal account before you lose access. Evidence you cannot reach is evidence that does not exist. Step 3, note every age-coded phrase you have heard. Fresh perspective, more energetic, new direction, and write down who said it, when, and in what context. Step 4, identify your comparators. Who is younger than you in a similar role? Were they treated differently? Promoted when you weren't? Retained when you were let go. Write down the names and situations. Step 5. Do not sign any severance agreement or release of claims without an attorney reviewing it first. You have at least 21 days. Use them. Age discrimination is one of the most common and most underreported forms of workplace discrimination. Most employees never file a claim because they assume they can't prove it, or because they assume it's just how things work. It is not just how things work. It is illegal, and the law gives you real tools to fight it, if you know how to use them. Drop your situation in the comments. Anything at work seem fishy? And please, like and subscribe if this was useful. New video every Tuesday. And if you are ready to take the next step and actually file a complaint, I walked through the entire EEOC process in episode 7. What to file, where to file, and the deadline you cannot miss. That video is linked above.